I just flag it for your attention because it suggests that laws that would limit personal liberty without a justification beyond a straight moral claim face an increasingly uphill climb in our legal system. So the more pressing issue for religious health care providers is whether they will have the liberty to practice medicine in a way that is consistent with their beliefs. In other words, in my view, it's less a time to be playing offense, that is, seeking to conform law to the faith tradition's moral claims, and more a time to be playing defense, that is, seeking to maintain space in which to live out one's moral claims without interference from the state. For the foreseeable future, questions about the relationship between law and religion and healthcare will be questions about the liberty of conscience. Given the morally controversial nature of developing medical technologies and the centrality of healthcare decisions to virtually all modern conceptions of individual autonomy, healthcare is a primary battleground for today's conscience debates. Patients are understandably concerned at the prospect of a provider's moral qualms limiting the available range of treatment options, even if the patient finds the treatment to be morally acceptable. Providers are understandably concerned at the prospect of the state acting on the patient's behalf, compelling them to violate their own moral convictions. So one example I'll just talk about briefly is the rights of pharmacists. Some states now, just about every state has taken this up in some form or another. Some states now have legislation protecting the pharmacist's rights not to dispense drugs that they find morally objectionable, while other states have laws ensuring that a pharmacist's conscience does not interfere with a customer's ability to obtain a legally prescribed drug. Washington State, for example, requires all pharmacies to fill all legally valid prescriptions on site, effectively ending what had developed into the practice, allowing pharmacists to decline to fill a prescription on moral or religious grounds and refer the customer to another pharmacy. The debate has also occurred at the federal level, as some of you have probably followed. Just last month, President Obama replaced the Bush administration's conscience rule for healthcare providers with a narrower version. Supporters claim that the changes are a win for patients, but critics claim that providers' rights have been trampled in the process. Well, conscience clauses have been common since Roe versus Wade. The notion that physicians should not be compelled to participate in a procedure as morally wrenching as abortion has not been especially controversial, and I still don't think it's as controversial as some of these other battles, although it's becoming more controversial. The advent of Plan B emergency contraception has driven pharmacists to seek the same protection enjoyed by physicians. Some pharmacists believe that Plan B functions as an abortifacient by blocking the fertilized eggs implantation. Along with pharmacists' expanded discretion as gatekeepers to pharmaceutical care, the widespread availability of Plan B has really provided a spark for the conscience controversy. But it's now spilled over into the dispensation of other drugs, including the more common birth control pills, and in a few cases, other medications like antidepressants. As pharmaceutical technology encompasses moral hot potatoes such as genetic screening tools, research derived from embryonic stem cells, or race-specific medications, the stakes and the passions will likely be ratcheting up in the future. Now, obviously, the pharmacist controversy is just the tip of the iceberg. Other controversies include debates over whether Catholic hospitals should be required to provide emergency contraception to rape victims, a physician's or a hospital's authority to resist financial and family pressures regarding end-of-life care, and discrimination by providers on the basis of marital status or sexual orientation. Just a couple of examples on that last point. In Ireland, a Catholic physician was part of a clinic dedicated to practicing medicine consistently with church teaching. As such, he declined to provide fertility care to a woman who was not married. He was brought before the board on fitness to practice charges. Fortunately, thanks to Farr Curlin, who's here with us today, he won the case. But the point is, he had to defend himself as fit to practice because of how he had decided to devote his practice. In California, a physician declined to provide fertility care to an unmarried woman who was also gay. There's some dispute as to which was the basis for declining the care, and he was held to have violated the state's anti-discrimination law, and that went all the way up to the state Supreme Court and was upheld as fine, that he could be sanctioned for that. So from a legal perspective, how should we think about these controversies regarding religious conviction and health care? Well, people reflexively want to go to the Constitution and say there's got to be a constitutional right in here somewhere. And there's arguments to be made, but the Constitution doesn't help us sort it out all that much. There is a Supreme Court case called Employment Division versus Smith. And what Smith said is if a law is neutral and generally applicable, the fact that it might burden someone's exercise of religion is irrelevant for purposes of the free exercise clause of the First Amendment. So if you have a law that's neutral and applies across the board, the fact that it might make your religious convictions much, much harder to live out, that's not an infringement on your religious liberty. All right? As such, the cause of liberty in this area is more of a political issue than a constitutional one. It's going to be settled in legislatures much more than it's going to be settled in courts. As a society, we're going to need to engage in a conversation about what the law should be on these issues. Even resorting to the liberty of conscience as traditionally understood is not all that helpful. We're used to the law defending conscience when the individual is pitted against the state. Right? The classic examples of liberty of conscience are the individual inducted to serve in the military, or back in the early 20th centuries, a Jehovah's Witness student being compelled to participate in the Pledge of Allegiance. Those are the classic liberty of conscience cases. The individual against state power. It's very easy to figure out whose side conscience is on. It's the individual. But now, when the battle is between provider and patient, right, how does conscience shake out in this context? It becomes much more complicated. And the inquiry is complicated even further by what I see as three primary trends that we need to be aware of. So let me just spend a few minutes outlining those, and then I'll close. The first trend: much of our political discourse reflects a changing view of professional licenses, moving from what I see as a competence regime to a normative regime. The easy response to any call for a professional right of conscience is, look, you may have a right to conscience as a private citizen, but state licensed providers are like public officials. The right to conscience doesn't apply. Along these lines, the New York Times editorialized that pharmacists who refuse to dispense contraceptives are engaged in an intolerable abuse of power and need to find another line of work. The National Organization of Women went higher up the chain of being, labeling such pharmacists as extremists arrogantly playing the role of God. Among the problems with this argument, in my view, is that it rewrites the history and purpose of professional licensing, which has traditionally been aimed at ensuring competence, not at co-opting providers into serving state interests at the expense of their own moral agency. Lawyers, for example, are free to decline representation that they find morally repugnant, and the bar's licensing inquiry focuses on competence and character, not on the lawyer's willingness to take on whoever walks into the office. Now, it doesn't translate directly into the medical field, but there's still there's a changing focus from competence to the other in some of these arguments. We want professionals to be morally engaged with the work they do. As the 20th century made all too clear, we take on significant risks when we encourage, much less require, the professional's role to define the professional's conscience. The second trend: there's a trend away from rights as negative liberty, that is, prohibiting the state from interfering with one's pursuit of what they deem to be the good, toward rights as a positive liberty, that is, empowering individuals to enlist others to help in their pursuit of what they deem to be good. This makes the question of religion and healthcare much more complicated. We recognize that the existence of a legal right does not mean much absent ground-level empowerment to obtain the good or service to which the right is attached. This dynamic is especially apparent in the reproductive rights arena, where the focus has shifted from decriminalizing abortion and contraception to insisting that the individual must have unfettered access to abortion and contraception. Not only should the full range of pharmaceuticals be available at every pharmacy, but they must be provided, in the immortal words of former Illinois Governor Rod Blagojevich, with no hassle, no delay, no lecture. The fact that the state can't forbid the provision of a particular good or service is taken to mean that every good or service must be provided by all licensed providers. In the process, the moral convictions of providers are rendered irrelevant. The individual consumer or patient does not just coexist with the morally divergent views of the provider. The individual, backed up by state power, trumps the provider. I don't mean to suggest that access to morally controversial goods and services is not an important public value. But the enshrinement of universal access as a precondition for participating in the healthcare market imposes significant costs on other important public values, the liberty of conscience most glaringly. Medical rights as a positive liberty result in a strangely amoral vision of healthcare. The former Democratic governor of Wisconsin, for example, justified his veto of a conscience bill for healthcare providers on this ground. He said, quote, "You're moving into very dangerous precedent when doctors make moral decisions on what medical care they'll provide," unquote. I would argue that you're moving into very dangerous ground when a governor rejects the possibility of doctors making moral decisions about the care they'll provide. The third and final trend, many supporters of an individual right of conscience are more skeptical of extending those rights to an institution. Even if we're comfortable with an individual physician having a right not to participate in a controversial type of care, we might resist giving a hospital or clinic the power to withhold the availability of a certain service. In my view, this resistance is unfortunate because it marginalizes the institutional liberty that is essential for the long-term flourishing of conscience. For example, the rise of small pro-life pharmacies is viewed with dread in some quarters. Institutional liberty appears more threatening than individual liberty. The ACLU recommended in a report advocating for laws requiring pharmacies to satisfy any lawful request for birth control that, quote, institutions when operating in the public world ought to play by public rules. I would agree with that to an extent, but I would say we need to be careful about how stringent we want to make those public rules when they intrude on the possibility of institutional identity. Viewing institutional market actors as an extension of the state does not bode well for the liberty of conscience. The state honors its citizens' claims of conscience by ensuring the conditions necessary for the moral conversation to continue, not by imposing one set of claims over another. In my view, one key to navigating these tensions in the future is to recapture what I call the relational dimension of conscience. That is, the notion that the dictates of conscience are defined, articulated, and lived out in relationship with others. American law has traditionally had a very individualized conception of conscience, and we need to work toward expanding that conception. Our consciences are shaped externally, our moral convictions have sources, and our senses of self come into relief through interaction with others. By conveying my perception of reality's normative implications, my conscience makes truth claims that possess authority over conduct, both my own conduct and those who come to share my views and over their conduct as well. Conscience, by its nature, connects a person to something bigger than herself, not only because we form our convictions through interaction with others, but also because we invest those convictions with real-world authority in ways that are accessible, even if not agreeable to others. Conscience might be expressed and defended by the individual, but its substance and real-world implications are relational by their very nature. Cultivating and maintaining these conditions necessary for these relationships to thrive should be a priority for our society if we're serious about freedom of conscience. Now, let me wrap up by noting that I'm not an expert by any stretch on Islam or its past relationship with American law. But I will note that the political dimension of this relationship is even more complicated in the Islamic context, in significant part due to the near hysteria in some parts of America regarding the perceived threat posed by Sharia law. Addressing religious liberty at the institutional level becomes more complicated for Muslims because of our society's knee-jerk assumption that institutional efforts to either reflect or accommodate religious convictions are somehow equivalent to the legal enshrinement of those convictions. Hence the controversy in some circles over something as simple as banks offering Sharia-compliant financing alternatives, or the Oklahoma law recently passed banning courts from considering Sharia law. Now, this statute pulls off the very difficult task of simultaneously violating both the Establishment Clause and the Free Exercise Clause, in my view, which is a very rare trick. They do that. But for our purposes, what's relevant is the premise of this law. The premise of this law makes it extremely difficult to have a distinct institutional identity if you don't know that the rules on which the institutional identity is grounded will be enforced in a court of law. That's what makes it so difficult. Excellent. Just about done. I can't see the future on this, but the current public mood poses additional hurdles for Muslim providers to live out their faith commitments at the institutional level. I think that much is fair to say. Regardless of the policy resolutions reached in a specific healthcare dispute, in my view, it is important to reorient the conversations about law and religion and healthcare toward what is at stake. In a functioning marketplace, the viability of conscience requires us to give providers and like-minded customers an opportunity to live out their faith commitments. By more steadfastly defending the social space in which individuals and groups can live out the dictates of their consciences, even when, especially when, those dictates have been rejected by